When does the child of someone who was living in the United States as a green card holder but became a citizen become a citizen themselves? Hi, I'm Jim Hacking, immigration lawyer practicing law throughout the United States out of our office here in St. Louis, Missouri. This one's a little bit convoluted, so let me walk it through with you. You know, our office gets a lot of calls, and this week we got a call from a gentleman who had been a longtime citizen in the United States, but he had children born overseas, and he had never applied for them to come to the United States. And last year they came as green card holders, and he was wondering what are the conditions that have to be met in order for such a child to obtain citizenship by operation of law. So here's what happened. This man came to the United States many years ago, and he spent a lot of his time here and a lot of his time home back in his country of Jordan. His wife had also gotten a green card, but she decided that she wanted to go back. And so he actually ended up having 4 children back home in Jordan, and they were all living in Jordan, and last year he petitioned to bring them all here. Now it turns out that 6 years ago he became a U.S. citizen. So here we have a situation where the children were born overseas. They were born at a time when their father was a green card holder, and the father had subsequently become a U.S. citizen. And this father had been able to bring all of the children to the United States. So the question is, when do they become citizens, and even if they become citizens? And here are the conditions that must be met in order for such a child to become a U.S. citizen. The first thing is they have to be in the United States in lawful permanent resident status. So the man had successfully gotten green cards for all of his children. He had filed I-130 petitions for an alien relative for his wife and for the children, and they were all living in the United States. So that first requirement was met. The next requirement is that they have an actual green card. So they all have green cards, they're all lawful permanent residents, and they're all residing here in the United States. The next question is one of their parents a U.S. citizen? So here, obviously, the dad had gotten his citizenship about 6 years ago, so that requirement was met. Then the last requirement is, does each child live in the custody, with the custody of the U.S. citizen parent? And here the parents are living together, and everybody's here in St. Louis. And so the question is, have they satisfied all of the requirements? And the good news is they have. So now what they're going to need to do is to file an N-600. This is a different form than an N-400. An N-400 is to naturalize someone who's already a lawful permanent resident. Here, these children are already citizens by operation of law. That is, they could not be deported. Now we just need to convert them in the minds of the immigration officials from a green card holder to a U.S. citizen, and you do that by filing an N-600. And basically, you have to prove that each of those requirements are met, that the kids are green card holders, that they're residing in the United States, that their father or mother is a U.S. citizen, and that they are living in the custody of that U.S. citizen parent. So those are the things that need to be established by the N-600. So we're going to go ahead and file those for them and get that case started. If you have any questions about this, I know it's a little bit convoluted, be sure to email us at jim@hackinglawpractice.com, or you can call me at 314-961-8200. And if you like this video, we hope that you click on the like button below and make sure to subscribe to our YouTube channel so that you get updates whenever we shoot new videos like this. Thanks a lot. Have a great day.